Well, hello everyone, and thank you for joining me today. My name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning here in Washington State. Our topic today is going to be the top 3 estate planning mistakes to avoid. So for those of you who are live with me today, go ahead and put your questions in the chat. If you're on Facebook, go ahead and put your questions in, and I will do my best to answer all of those questions for you today. So a little bit about what we're talking about. We're talking about estate planning, the top 3 mistakes. I am an estate planning and elder law attorney, and we are going to be talking a little bit about what the distinction is between those two. Also, I am coming to you from Washington State. So if you are listening to this from another state, you may want to consult with an attorney in your jurisdiction, because some of the things that I'm going to be talking about are not true in other states, especially when we start talking about revocable living trusts. So what are the 3 estate planning mistakes that people typically make? Really, the number 1 mistake, and we see this just by all the numbers, is that people don't think that they need an estate plan for a variety of reasons. They don't think that they need an estate plan, maybe because they're too young, they don't have enough assets. That is probably the biggest mistake people make. And I'll explain to you why it is an estate planning mistake. Primarily because you think that because you don't need an estate plan, because you're too young or you don't have enough assets or whatever it may be, you think you don't have an estate plan. Well, you do. And I'm going to tell you what your estate plan is. It's not the one that you want. It's the one that the state says you have. So that's number 1, is people just not understanding and realizing they need their own estate plan. Number 2, that, okay, well, you wrapped your mind around, I need an estate plan and I'm going to just take care of it myself because it can't be that complicated. I want my life to be simple anyway. And you go to the internet or you download a form, or perhaps you say, you know what, I know I have a lawyer that I worked with. They helped me with another situation. The lawyer said that they can do my will for me, and that's all I need for an estate plan, right? So you go to a general practitioner, you get an estate plan done there. Or maybe you go to even an estate planning lawyer, but somebody that doesn't understand government benefits, elder law, asset protections that come with that. So the number 2 estate planning mistake that you can make is you don't go to the right legal counsel, the qualified estate planning elder law attorney, to get it done. We're going to talk about that. The number 3 top estate planning mistake people make here in Washington is that they rely on revocable living trusts. So as I said, if you are listening from a different state, California or Florida, when I am saying I do not recommend revocable living trusts in the state of Washington, what I am saying is probably not true in the state where you live. But if you listen in, you'll understand why I say that having a revocable living trust could be the worst mistake anybody can make if they live here in the state of Washington. All right, let's go ahead and get started. Number 1 mistake. People thinking that they don't need an estate plan, completely understandable, because actually, if you're still thinking and living and you're here with me, you're saying, I don't need an estate plan. Nothing has happened to cause me to need an estate plan. And this is so understandable human nature. We don't like to think about the fact that we will pass, and we sure hope we are never disabled. And nobody wants to think about that. So when people think that they're too young for an estate plan, I might agree that they are too young to have a will, but I will not agree that they are too young to have estate planning documents that include durable powers of attorney. So let me back up a little bit. What is an estate plan? An estate plan is a set of legal documents with the guidance that you have as to what is appropriate for you and for your situation. That's one of the reasons internet online forms don't work really well. We'll get to that. Most of us think that an estate plan is only what happens to us on our death. That is not an estate plan. That's basically what a will covers, is what happens on your death. So if you're young, absolutely you are not thinking about dying. 21-year-olds, for example, when I last looked it up, they have a life expectancy. They'll live to 76. Why in the world would a 21-year-old be thinking about an estate plan and a will? They're not going to. You know, when you get a little older, in your 30s and your 40s, you know, maybe you're going to say, you know, I probably need an estate plan because I have minor children. When you get to middle age and retired, you're thinking, well, you know, I probably need an estate plan because I have to deal with what's going to happen on my death. Yes, it's very important to deal with your assets on your death. And thinking that you're too young is kind of missing the point about the most important parts of an estate plan. So let me get into that just real quickly here. Estate planning documents typically include your will, your durable powers of attorney for finances and for health, and your healthcare directive. Those are the fundamental pieces of an estate plan. And if you don't have a will, perhaps you have a revocable living trust, and then you have a will. It's called a pour-over will to capture everything you didn't put into your trust. Those are just basics. I'm not going to get into all of those. So a young person, maybe they have no assets. And of course, they're not thinking about disability. They're invincible. Recall that when you were young. But we all do know that things happen, accidents happen, people suffer some sort of some perhaps catastrophic injury where the person cannot manage their own affairs. So what happens if they don't have their durable powers of attorney in place? And this doesn't have to be for a young person, but I'm kind of emphasizing this because if you have kids that are either college age or older, and if they don't have at least durable powers of attorney in place, if something very tragic should happen to them, they are left with an injury that doesn't allow them to manage their own affairs. You won't be able to manage their affairs for them. They won't be able to. Well, who does? This is what I'm saying. The state has an estate plan for those who have not done planning. And the state's estate plan for somebody who doesn't have a durable power of attorney in place is a court-ordered guardianship or conservatorship. The person who has lost capacity becomes a ward of the state. All of their affairs, their financial affairs, their personal affairs, their medical decisions, everything is court-ordered, court-controlled, not family-controlled. Now, maybe, you know, the court would appoint you as a family member as a conservator of your son's estate, for example, or maybe not. Maybe it's somebody else. As I was saying, totally understandable that people don't want to think about death or disability. And I'm not expecting anybody who is younger and listening to this is going to say, oh yeah, I'm going to go out and get my durable powers of attorney. This is more for those of you who are thinking about, hey, I have an adult kid. My adult kid is married now. They don't have any estate plan in place. They certainly don't have any durable powers of attorney in place. And of course, as a parent, we never, ever want to see our children hurt. But if something were to happen, it really makes a situation far better if they have designated a trusted individual to serve as their power of attorney on their behalf, so that the court is never involved in any decisions that are made about their finances or about their health. Instead, it's the family who's involved. So that's where, you know, people who are young, they really do need to have, at a minimum, their durable powers of attorney in place. Even if they have no assets, they need durable powers of attorney in place. So then let's move on to the people that think that, you know what, I just don't have enough assets to have an estate plan. You know, all I have is my bank account or my 401k and my car, and maybe I rent, or maybe I have a house and I have a mortgage. It's not wealthy, not wealthy. Why would I need an estate plan? Well, that's where the big misconception comes in, because when people are thinking about, estate planning, they typically think, well, I don't want to pay unnecessary estate taxes, or I don't want the state to get my estate. So let me help correct some misconceptions about this. We'll talk about when the state actually gets your assets, very uncommon. And if you are of the level of assets where you're going to be paying an estate tax, yes, you need an estate plan. In Washington, we have an estate tax credit exclusion amount of $2.193 million. Frankly, if you've got over $2 million, you're probably realizing you need an estate plan. If you are at you don't live in Washington, but you live in Idaho, Idaho doesn't have an estate tax, so you're only concerned about the federal estate tax level, which is being raised in 2023 to $12,920,000. If so, yes, you definitely have estate planning in place, because you do have a lot of money and you don't want to pay any unnecessary taxes. But let's talk about the people that don't have 2 million. Maybe all you have is 20,000. Maybe you have 200,000. Maybe you have somewhere in between. Is that enough for an estate plan to make sure your assets go where you want them to go? Well, I would argue it does. Even if you are just a younger person and all you have is 20,000, wouldn't you want to say, hey, I want my $20,000 bank account to pay on death to whomever? Or maybe if you have, what is that, 200,000, don't you want to make sure that it goes where you want it to go and that you protect it if there's a way to protect it? I think when people say my estate isn't big enough to have an estate plan, what they're thinking about is, as they see themselves, they don't see that their assets are that complicated or their life is that complicated. And it's kind of a paradox in that if you don't do an estate plan, even if you're in that situation, well, there's no plan in place that you put in place. But what's going to happen is it's going to get way more complicated upon your death. We've already talked about what happens if you don't have an estate plan and you become disabled, unable to manage your affairs. The state's going to take over for you. Not a good result. How about upon your passing? You have, an estate that's less an estate. I'm saying your money, your car, your house, your 401k, anything that is considered an asset, that's your estate. You pass away and you don't have an estate plan. What's going to happen? Well, the state has an estate plan for you, because the state there's got to be laws in place for where does this money go. So I want to tell you what happens to your assets if you die and you don't have an estate plan in place. So on your death, we have to do a factual inquiry as to what's your living situation. If you're married and you've been married for a long time and you live in the state of Washington, you probably know we're a community property jurisdiction. So if you are married and let's say you're, first time marriage, you've been married for 30, 40, 50 years, the state says the deceased person probably wanted their assets to go to their spouse. So that's what the laws of intestacy say, that if everything is community property, then everything will go to the surviving spouse. It doesn't go to the state. Don't be worried that, all your assets are going to go to the state. That doesn't happen. It'll go to your spouse. Let's say you're married and this isn't your first marriage, this is your second marriage. And maybe when you got into the second marriage, you had accumulated some property, your spouse had accumulated some property. That's called separate property. So this is where we get into a factual inquiry of what is the nature of the property, of the asset. It makes a difference. because anything that's considered community property all goes to the surviving spouse. But if it's separate property, the surviving spouse only gets 1/2 of it, and the person who died, their descendants split the other half. So there can definitely be litigation, factual inquiry. It can get quite messy when there's no will and there are people claiming that they're entitled to the property because it's separate property. So that's just one example of problems that can arise, because if the spouse who died simply had an estate plan in place, there wouldn't have to be this inquiry if they did a decent estate plan. Let's talk about a single person. What happens if there's a single person and they die and they didn't have a will, and where do their assets go? Well, they're single. So then the next question you ask is, do they have any kids? The answer is yes, then the kids get it. So let's say there's 3 children. Let's say, just easy math for me. The person had $300,000 in assets. They have 3 kids. Each kid is going to get $100,000. That's what the state thinks that the person would have wanted. Did they want that? I don't know. Maybe they wanted to disinherit a problematic child. That's not always the case, but it's not that uncommon. Or let's say it's not that situation. They wanted everybody to inherit the person. They never did the will. But maybe one of their children is a special needs child or something along those lines where they need asset protection. Well, if you don't have a will, you're not going to have asset protection anywhere, period, when it comes to the situation where the person wanted their special needs child to receive the assets and not get bumped off of needs-based government benefits. It's not going to happen. So what I'm saying is, if you don't have an estate plan, somebody I spoke to recently said you have a wing and a prayer estate plan, because you have the estate plan that the state puts into place for you. And that's not the ideal estate plan by any means. So no matter what your situation is, no matter what your age is, no matter what your asset level is, you need your own estate plan. You do not want to have the estate plan that the state has in place for you if you fail to do so. Let me just take a look at the chat real quick here and see if there's any questions on this I can answer before we move on. We're going to be talking about, one of the questions is about how not to lose your assets if your spouse needs to go on Medicaid. And we definitely will talk about revocable living trusts and if they make sense if you are a single person. So let's go ahead and move on and we'll get to those questions. Okay, so perhaps you're with me now and you say, yeah, I guess I do need an estate plan. That makes sense. I don't have to be rich. I don't have to be old and facing on death's door. We don't know what life is going to bring, and I want a plan that makes sense for me, that accomplishes my goals. Okay, what do? Well, a lot of people, and we all do this. I mean, who doesn't go online and research whatever they're looking for, right? You do Google research and you might come across something that goes, oh, this looks like a good deal. This is only $49.99 or $500, and I can do it online and it says it's coming from a law firm. So I think I'm going to just go ahead and do that. I can tell you, and of course, I have a strong opinion on this, being an estate planning and elder law attorney, is that if you are not getting that one-on-one counsel and guidance from an experienced attorney who knows their stuff, you're not going to have the right estate plan. You might have an estate plan, but is it going to protect you and accomplish your goals? I can tell you it will not. All right, so let's say you don't want to do an online estate plan. Then you're going to go and say, when said I should talk to an attorney, I'm just going to go talk to my attorney who helped me with my closing on my house or on my my divorce or whatever it may be. That is what we call a generalist. Well, not necessarily. Maybe all they do is divorces, and they say, hey, yeah, I can do your will too. They can't do your will too, or they can't do a good job on it. You know what? Family law lawyers may disagree with me, and I'll accept that. I believe that what a person needs is to go to a specialist. Think about the last time you went to your doctor and they said, well, you need to have this procedure. Did they send you to a generalist? They sent you to that orthopedic surgeon that you needed if it was a rotator cuff, for example. So a generalist is not what I would recommend. All right, so let's say I'm going to go to an estate planning lawyer. So what we're talking about here is the second biggest mistake that people make is not getting the right help they need for their situation. And I'm not going to say that everybody needs to go to an attorney who has elder law expertise, because remember I mentioned that the federal exclusion amount for estate taxes is in 2023 is $12,920,000. You are fine dealing with an estate planning lawyer who knows nothing about elder law. If that's all we're worried about is avoiding you paying estate taxes, they definitely can help you with that. And if you have a long-term care event or your spouse does, you can self-fund this. You can pay $150,000 a year, year after year after year for 10 years. It's not going to eat up your estate. You're going to be fine. So those that have a taxable estate problem likely don't need to see an elder law attorney. The only exception to that, I would say, is, you know what, if they have a special needs child or somebody that they want to make sure that they can protect that person's eligibility for government benefits, needs-based government benefits, even if they have that much money, they're probably going to want to bring an elder law attorney in to figure out the best way to set up the estate plan to protect that special needs child. But aside from that, people that have wealth above the, in the 8 figures, you're probably fine. You are fine with an estate planning lawyer with tax expertise. The majority of us, though, are people that are concerned about long-term care costs, concerned about spending money that's actually going to deplete their estate. And that's where elder law comes in. You see, an estate planning lawyer can prepare for you documents, but what they're not going to be thinking about, that an elder law attorney is going to be thinking about, is what happens if you're married, during your lifetime, you or your spouse need expensive long-term care. You need to be maybe at a memory care. You need to be at a skilled nursing. There's Alzheimer's diagnosis, and that person might need 10 years of memory care. That's a lot of money. That's likely over $1 million. What's going to happen? An estate planning lawyer is not going to be able to help you with that. An elder law attorney is, yes, an estate planning lawyer, but we also have knowledge of government benefits and how to protect assets so that government benefits, including the state paying for care, can happen. So the question, one of the questions in the chat here was, how do you protect assets when you're in that situation? Maybe you and your spouse have $1 million. You own a house that's worth $500,000 and you've got $500,000 in investable assets, and one of the spouses needs to go into memory care. Without having an elder law attorney, having prepared your estate planning documents, have the right durable powers and attorney in place, have the right will with asset protection in place, that couple may very well end up having enough money to pay for the first spouse's care, but the survivor is left with nothing. And that is really unfortunate when that happens. It happens way too frequently. This is what an elder law attorney would do. That couple comes to us, we have an Alzheimer's diagnosis for one, but they're not far enough gone that they don't understand their estate planning. Remember we had talked a little bit earlier about people being too young for an estate plan? Sometimes people can wait too late. Don't let that be you. even if there's an Alzheimer's diagnosis, that doesn't mean the person doesn't understand, but don't wait too long, because as an attorney, the person needs to understand their estate plan. And if they don't understand anything, our hands are pretty much tied with how we can help them. But we still can work with people with diminished capacity. Elder law attorneys do that all the time. We can still get a good plan in place. So we get the right estate plan in place, one that allows us to transfer all assets to the well spouse. That's usually done through some sort of property status agreement. And we transfer the house into the name of the well spouse. We transfer all the bank accounts into the name of the well spouse. And then once the care situation is determined for the ill spouse with Alzheimer's, then we can apply for Medicaid. And you might be saying, well, how does that work? I can tell you that when you were looking at Medicaid, when we're looking at memory care, most facilities with memory care will require 2 years of private pay. So it's not like we couldn't do the Medicaid qualification even with that asset level. We are more constrained because the care facility that's appropriate for the person with Alzheimer's requires 2, if not 3 years of private pay. What's paramount is the quality of care for the person who needs care. Medicaid is secondary to that, at least in my opinion. So maybe this couple does need to pay for the 2 years of private pay because they needed that facility to then say, okay, you paid for care here 2 years, now we'll accept Medicaid. So during that time frame, they spent down, $100,000, $200,000. That's simply how it works. Can I qualify that couple now? Let's say the wife has been in memory care for 2 years. Memory care will accept Medicaid. Husband now has $300,000 in the bank and the house. Yes, I can qualify that ill spouse for Medicaid. How do I do that? Medicaid in this situation says that the couple can only keep about $60,000 in countable assets. I said I had 300, got $240,000 too much. What am I going to do? Probably use a Medicaid compliant annuity. We've got other webinars on this, but a Medicaid compliant annuity is allowed by the state and allows you to take countable money and make it non-countable by putting it into annuity. And that annuity is accepted by the state. Wife goes on Medicaid, state pays for the care, husband gets to keep all of those assets. State has no recovery on that, assuming that the husband lives out the term of the annuity, which here in Washington is typically a 5-year. So I hope that answered the question about what do you do if there's long-term care costs, and does a couple have to spend down all their money? No, they don't. Why not? Because they're working with an elder law attorney that knows Medicaid's rules, and we know how to protect the assets. So that's where I was, talking about estate planning done by the correct professional. The correct professional, if anybody is concerned about the finances, the costs of long-term care, is going to be the correct professional is somebody that understands elder law, understands Medicaid qualification, understands the rules to protect assets. Who is concerned about long-term care costs? Well, certainly not anybody that's younger, usually, but if somebody is retired, we all know that as we age, care becomes more likely. Statistically, if you look on the internet as to what the chances about care are, if you are 65 or over, there's a 70% chance you are going to need long-term care. And that long-term care can be, just care at home, which usually the family members provide, or it could be at a nursing facility. And according to longtermcare.gov, 35% of people who are over the age of 65 will require 1 year of care in a skilled nursing facility. Well, that's about $12,000 a month times 12, that's 144. That's almost $150,000 a year. $150,000. And with an estate plan that has the elder law expertise incorporated into it, especially in skilled nursing care, I'm not talking memory care. Skilled nursing care typically does not have a private pay requirement. So typically we can preserve all of the assets for that couple, not just a portion of them. So when I talk about, the mistakes that people make, if they went to an estate planning lawyer who didn't know elder law, their will won't have what I call an asset protection trust in it. An asset protection trust is the type of a trust that in the state of Washington, the state says, oh, one of the spouses has died. They put all of their estate through their will, through the probate process, into this particular type of asset protection supplemental needs trust for the surviving spouse. Okay, we honor that, says the state. Let's say the decedent's share of the estate was $500,000. So $500,000 went into the trust for the surviving spouse. When that surviving spouse qualifies for Medicaid, is that money going to count against them? No, it is not. The state says, okay, you've got $500,000 in trust. We don't count that. All we count is the assets that are in your name. So a couple who lives in the state of Washington can, with assurance, protect at least half of the assets for the surviving spouse against the necessity of spending them down once one of them has died. That's what an elder law attorney will virtually always include in a will for somebody who's concerned about long-term care costs, which frankly is the majority of people, especially if the asset level is $2 million or less. Protecting assets against long-term care costs, that is a skill and expertise that an elder law attorney will bring to the table for you. And by the way, it's not just against long-term care costs, it's against any other threats like this asset protection trust protects against estate taxes. It makes sure that the assets of the deceased spouse will go where the deceased spouse wanted them to go, which means that it'll go perhaps to the couple's children or whatever they decided upon. It's the assets in this trust are immune from any creditor's claims. So it really protects assets from multiple threats, not just long-term care threats. Another thing that I wanted to point out about working with a qualified legal advisor that is an elder law attorney and not just an estate planning attorney is that if you ever do need any asset protection in the future against long-term care costs, the attorney is going to be that same attorney you worked with. We don't have to refer off somebody. If I was just an estate planning lawyer and I knew nothing about elder law or Medicaid or government benefits or Medicaid asset preservation strategies, if I didn't have that level of expertise, if we didn't have that at ELG estate planning, I would say, I'm so sorry, I can't help you. I don't know what to do. I have to refer you to an expert who has that. So if you start, and when you're working with somebody on an estate plan, even if you're younger, even if you don't, heaven forbid, nobody wants long-term care in their future or disability, what's the benefit of working with an estate planning lawyer with elder law expertise? They'll be with you for the rest of your life. They can help you no matter what happens. You will not need to be referred off if long-term care does come up in your future for you or for your spouse or family members. You are with that legal counsel who can guide you through that journey, no matter what happens in life. And of course, handle your estate upon death. So the benefits of working with an elder law attorney, and that doesn't even, I'm just talking about the legal benefits. Having been through 14 years of long-term care with my own parents, I understand that there are a lot of resources that are out there. You don't have to do this on your own. It's not just the legal help you get, it's knowing that there are people called, aging care managers, and who to contact for, do you need an estate sale? Who do you contact? What plan should you be putting in place? Somebody that's been through a long-term care experience has a wealth of knowledge that those who haven't been through it wouldn't be aware of and wouldn't know those resources. So again, obviously, as an elder law attorney, I recommend that you work with an elder law attorney if it's appropriate for your situation, which means that you're not at that, federal taxable estate level, and all you're trying to do is avoid paying estate taxes. Number 3, biggest estate planning mistake you can make here in the state of Washington is having a revocable living trust. And you are that couple that I just described with, for example, $1 million estate and the wife has Alzheimer's. Why is that? Now, if you're listening again from outside of the state of Washington, you're going to think that I don't know what I'm talking about. Because if you're in Florida, if you're in California, every pundit you've ever listened to is going to say you should have a revocable living trust. That's what the words of wisdom are. What is a revocable living trust? And why is it beneficial? And why do all these other attorneys and financial planners all throughout the US say you should have a revocable living trust? A revocable living trust is intended to avoid probate. Probate is the legal process where your estate is administered. Probate can be a very expensive and complicated legal procedure in a lot of states, not Washington. I don't have a license in California. It is my understanding in California, though, that probate is really to be avoided because the costs of probate are a percentage of the value of your estate. That can be huge. And in California, where they have Medicaid, the state of California will allow you, through a revocable living trust, to do asset protection for your surviving spouse against long-term care costs. So maybe a revocable living trust probably is the best idea in California. I can't say. But what I can say is in Washington, it can be a terrible idea. Recall when I told you about how with having a will with an asset protection trust, the couple can protect half, if not more, of their assets when the first spouse dies. So that when the surviving spouse applies for Medicaid, the state doesn't count that $500,000 in my example that was put in the trust, that $500,000 that was the deceased spouse's share. If you, instead of having a will with an asset protection trust and you live in Washington, you have a revocable living trust and you try to create that asset protection for your spouse, you can't do it. The state of Washington is clear. It is black and white in our state that if you want to protect assets for your surviving spouse when you die, so that the state of Washington doesn't count those assets, you have to do it through a will. You cannot do it through a revocable living trust. So a revocable living trust, I am not saying that they never make sense in the state of Washington. I'll talk about that in a minute. What I'm saying to you is that the concept of a revocable living trust, the idea that a revocable living trust fixes everybody's problems, you avoid probate, you get all the benefits of any estate planning, that's nonsense in our state. It's nonsense. You want to protect assets for your spouse against long-term care costs, you must do it through a will. And anybody that waffles on that doesn't know what they're talking about. So do we at ELG Estate Planning prepare revocable living trust for clients? Absolutely we do, but only if it's an appropriate situation, only if it's appropriate to avoid a probate. And, more commonly probate is beneficial. All right, so I'm talking about probate. I just said will revocable living trust. What am I talking about? Remember, a revocable living trust is to avoid a probate. All assets are supposed to go to whomever you said they go to, and you don't need to file a will with the court or do anything. You can just transfer assets to whomever. That's why it's very attractive. But in Washington, like I said, to protect assets for your surviving spouse, you need to do it through a will. A will must be probated if that is how your estate is administered, through a will. A will is required to set up this asset protection trust for the surviving spouse to protect assets against long-term care costs and get Medicaid eligibility. Okay, a will is required. It has to be probated. We're talking about Washington. Probates in Washington are what's called non-intervention, means the court is not involved other than you open the probate, you file a petition with the court, letters are granted to the executor, the personal representative, and they go gather the assets, pay off any legitimate claims, take the funds, and then put them into this supplemental needs trust. Probate will require, and I believe should require, the attorney to assist the personal representative through that process. Yes, anytime that you are actually working with a lawyer, you are paying them money. Money will be paid to create your estate plan, no matter what it is, unless you do it yourself. And it will be required to do a probate, unless you try to do it yourself, which we really don't recommend, because when you're putting $500,000 into a trust, you don't want to make a mistake. And if you're doing it yourself, there's room for error. Is this the fees to the lawyer for a probate going to be a percentage of the estate? Not in Washington. It's going to be dependent upon how many hours they actually put into it. And in terms of what is that cost, let's say that cost is $5,000. Let's say that cost for the probate is $10,000. Is it worth paying the attorney that amount to protect $500,000? Cost benefit analysis. Or instead, do you prefer to have a revocable living trust where you don't go back to the lawyer who helped you set it up, and you do, your spouse dies, you just put all the assets into your name now, and then you need long-term care. You have to spend down all of your money down to $2,000. You have no nest egg you can put aside, all because you wanted to avoid a probate. And in my opinion, that is really not the best plan. And if you had, an opportunity to talk to the attorney, to understand it, to ask these questions, which, by the way, please ask your lawyer questions, and ask them questions so that you understand it, because they should be able to explain in plain language, how does your estate plan work? How does it benefit you? What's going to be involved when you die? All of those things. You shouldn't go away saying, I'm still confused. All right. Revocable living trust. One of the questions asked was, do I recommend that for a single person? Depending on the situation, I'll recommend it for a single person or for a married couple. It's all factually dependent on their assets, their estate, what they want to accomplish, how complicated it is, how simple it is. But just don't buy from anybody that tells you that a revocable living trust is the cat's meow. It's what you need. That's what you need. Let me give you an example of somebody who the lawyers said you need a revocable living trust. Single guy, no kids. I think literally 18 nieces and nephews. And all he wanted in a very modest estate, like a bank account and a house. And his revocable living trust said, everything goes to my favorite nephew. All my assets, my house. Makes sense. How is he to understand that in order for this trust to work, he needed to retitle his bank account into the name of the trust, and he needed to put his house, the deed of his house, into the trust. The lawyer didn't help him with it. Most lawyers do. This lawyer didn't, unfortunately. So that when he died, there was nothing in the trust. It was unfunded. As a result, it had no control over any of his assets. So what happened was, and if you have a revocable living trust, you know this, you have something that's called a pour over will. What it means is if I forgot to put any assets in my trust, then my will is going to capture those assets and put it into the trust. So what happened with this gentleman was we had to file the will with the court, captured his bank account and his house so that it would go to the trust, and then it would ultimately go to the nephew who he wanted to get it. All of this unnecessary work, because all of the 18 nieces and nephews were the heirs at law, they all got notice of what was going on, which is not what he wanted. So a revocable living trust theoretically can work. Practically, it often doesn't. What would we have done for this gentleman? We would have avoided probate. We would have had a will that says everything goes to the nephew. We wouldn't have done a revocable living trust. We would have instructed our client to put a pay on death provision on your bank account, goes to my nephew, and a transfer on death deed on your house. So when you die, goes to your nephew. Nothing has to be done other than the nephew takes the death certificate to the bank, files what's called a real estate excise tax affidavit with the county. He owns everything. There's no probate. There's no estate administration. It was done. So my point is that revocable living trusts are often presented as being what everybody needs. And oftentimes they are absolutely the wrong thing for people. Those are the top 3 tips on how to avoid making some big errors in your estate plan. I'm going to look here at the chat. Oh, this is a good one. What happens when a single person has a will and an estate plan in place, naming the 3 kids to inherit the house of assets, and then they remarry? That's a great question. So one of the things we tell our clients is if you remarry, come back and see us, because there are definitely arguments that the spouse who is not named in a will can make to receiving assets under various theories of equity and contract, and partnership. Also, there's something that's called a family allowance award, and the surviving spouse can say that they're entitled to that because their spouse did not provide for them. The family allowance award statute in Washington was just recently changed to increase from what had been $50,000, that was a long time ago, to $125,000. And now it's to the mean value of the real property in the county where you reside. So if you reside in King County, I think that's like 900 some thousand or 750. It's a lot. And so what happens is if you remarry and you don't name your spouse in some way, that new spouse, they have a claim to your estate that is inconsistent with what your will says. So definitely, if you get remarried, go back and see your attorney and make sure that the estate plan is what you want. And of course, your spouse needs an estate plan too. Next question is, can IRA funds be put into a trust? So when you hear the word trust, the next question you should ask is, well, what kind of trust are we talking about? Because there's revocable trusts, there's irrevocable trusts, there's special needs trusts, there's supplemental needs trusts. Trust just raises more questions. So I'll answer it as the best I can. So let's say that you want to provide for your spouse when you're gone, and you want your IRA to pay to the supplemental needs trust that your will creates for your spouse. Yes, Your IRA can pay to that trust as long as you put the correct beneficiary designation on it to say it pays to the supplemental needs trust created by my last will. Can somebody's IRA be put into the supplemental needs trust if they haven't died? No, that can't be. What other types of trusts or IRAs and trusts? Typically, the general rule is that you can't put your IRA into a trust while you are alive. There are a lot of exceptions to that. Different lawyers will do different types of trust just for your IRA. And that is beyond my area of expertise. If somebody were asking me how to do that, I would say that's not my area of practice. Next question. What was that third document I talked about? So I talked about fundamental estate planning documents. Consists of typically your will and your revocable living trust if that's appropriate. So those are generally thought of as what happens on your death. Though, of course, a revocable living trust also controls your assets while you're alive, especially if you're incapacitated. But let's just talk about those as death documents. Your living documents are your durable power of attorney and your healthcare directive. Here at ELG Estate Planning, we do durable powers of attorney separately for financial matters and for healthcare matters. So can you have a combined durable power of attorney that addresses both? Yes, you can. The reason that we have it separate is ours are more comprehensive with more authorities. You might name different people. And so we find it works better to have separate durable powers of attorney for finances and for health, though that's not necessary. You can have a combined one. And the third in answer to that question in the chat was healthcare directive is an essential estate planning document that you need. Healthcare directive is called your living will. It's called your advance directive. Basically what that document is the document that says what your wishes are. Assuming you are at end of life, the doctor has said there's no reasonable probability that any medical treatment is going to make you better. You're at end of life. Now, do you want those who are making decisions for you to allow you to pass with maybe comfort measures, pain medication so you don't suffer? Or instead, do you want them to continue to offer what are usually called heroic measures to keep your body going because you want an opportunity for a new medical treatment? I can tell you the majority of people just say, please let me pass peacefully, but it's your individual decision. Nobody can tell you what's right and wrong. It's whatever you want. Just put it in writing so it's clear. That's your healthcare directive. That's what we call it here in the state of Washington. And then your healthcare agent, that's the person you appointed under your durable power of attorney for healthcare. They're going to be the one being your voice, expressing what it is you want. All right. Boy, we are almost to the end of the hour here. I did talk a lot today. I'm so glad that you stayed with me here till the end. I do want you to know that we will be sending, for those of you that we signed up for the webinar, a free estate planning guide. It has a lot of this information in it. So we will be sending that off to you. And of course, if you're watching this at a later date, if this is on our YouTube channel, and if you like it, please let us know, give us a thumbs up, please subscribe, please share this information with anyone that you know that might benefit from it. I'm Lynn St. Louis, this is ELG Estate Planning. And if you want to reach us by phone, it's 509-468-0551. And our website is elgwa.com. Thanks again and take care of yourselves.